Hello, everyone, and welcome to SCORE Fairfield County's live webinar on Workers' Compensation Primer for Employers and Business Owners. I'm Bob Hogan, the webinar coordinator today and a business mentor here at SCORE Fairfield County. I'm going to be your host today, and our presenter is Kathy Boufford. More on Kathy in just a minute. This webinar is being done in collaboration with the Monroe Chamber of Commerce and the Edith Wheeler Memorial Library. And in that regard, I'd like to invite Beth Stoller from the Monroe Chamber of Commerce to also give some brief introductory remarks. Beth?
Great, thank you, Bob. Good morning or good afternoon, everybody. Let me start with a fun fact, first of all. Welcome to National Pie Day. Not the kind of pie that you eat, although I'm sure there are plenty of bakeries and pizzerias that might beg to differ. Today is Pi Day, the Greek letter that refers to the circumference of a circle. So today is a day that combines fun and education. I just shared the fun. Now on for the education, which is the reason we all came here together. As Bob said, on behalf of the Chamber, the Edith Wheeler Memorial Library, and SCORE, welcome to today's Lunch and Learn. We have been putting these presentations together for over 5 years so that we can bring you great business-driven topics to help you grow as a business professional. If there's a topic you're interested in, I will put my email in the chat screen. I'd appreciate hearing from you so that we make sure that we bring you topics that are of great concern. I know you're in for a great webinar today. Attorney Kathy Boufford has been working with clients and workman's comp claims for many years. As a business owner, we all know how important it is that we understand workman's comp for our business. Before I turn this back over to Bob and Kathy, I just want to let you know that we are in the middle of our Build Your Business webinar series, sponsored by the same 3 organizations and also the Monroe Economic Development Commission. We are coming up to week number 5 out of our 6 Thursdays. We have 2 more weeks to go, this coming Thursday and a week from Thursday. This Thursday's topic will be e-commerce strategies, and next Thursday will be the importance of surrounding yourself with trusted business advisors. I will also share the link to register for these events. And now, thank you, Bob. I'll turn it back over to you.
Great. Thanks very much, Beth. Now, just some brief information on SCORE. SCORE is a nonprofit national partner of the SBA. And locally here at SCORE Fairfield County, we have over 100 volunteers with a wide range of industry, process, and subject matter expertise. And we offer 3 primary value-added services. First of all, we offer one-on-one business mentoring, and you can access that in person, by video, by phone, by email, however you would like, by using the yellow bit.ly link on the screen, or you can go to our website and click on the Request a Mentor link. Secondly, we offer a wide range of business education programs like the one today, roughly about 100 throughout the year. And lastly, we offer extensive resources on our website, including access to subject matter experts. Our next live webinar, as Beth mentioned, is going to be this Thursday, March 17th at noon. And the topic is Marketing the E-commerce Business with Cliff Enico presenting. And again, you can find more specifics on our website, fairfieldcounty.score.org. And if you're on our website, you can also access a large array of archived webinars on demand at any time. Just some logistics about today. We have set aside time for Q&A. And if you would like to ask a question, please hover on the bottom of your screen and use the Q&A button there. Kathy will take some during the presentation, but anything that we don't get to during the presentation, we'll take them at the end. Our webinar will end sharply at 1 o'clock to respect your time, and the session is being recorded, and the link to that recording will be available on our website, fairfieldcounty.score.org, within the next couple of days under on-demand webinars. It's now my pleasure to introduce our speaker today. Kathy Boufford is an attorney and has been practicing law for 25 years. She is the co-owner of the law office of Bellenot and Buford in Monroe. Most of her time is spent representing and advising people in the areas of workers' compensation and family law. In addition, her background also includes extensive knowledge in how to effectively manage and run a legal practice. She actively pursues her own continuing legal education and is committed to staying abreast of the ever-changing legal landscape. I'll now turn it over to Kathy. Kathy, it's all yours. Just remember to unmute. There you go.
Hello, everybody, and welcome. We're going to jump right in because there's a lot of information here. We're going to try to get through today as much of it as possible. So you're talking to an attorney, and of course, we're going to start out with a couple of disclaimers. First of all, this is a limited scope presentation, although I fully intend to give you a comprehensive overview of workers' compensation, especially from the employer's standpoint. It's certainly not it's going to be all you ever need to know about workers' compensation. So just bear that in mind. Everything I say, or just about everything I say, is really going to, there's a lot of qualifications. There's always the exceptions to the rule, which is what a lot of litigation, covers. So we just, this format is not designed to cover all of those exceptions. So I might point those out to you, but understand that we're not going to be able to get into all of those things today. Although I'm an attorney and I'm hosting this or presenting, I'm not. You can't consider what I'm giving you legal advice. There's no attorney-client relationship in this webinar. And just so you know, even though I am qualified to give this presentation fully, I spend most of my practice, at least on the workers' comp side, represented injured workers, not the employers. So keep that in mind as we go away. So a little bit of perspective. So with that, we will start. So what is workers' compensation? Workers' compensation is insurance that covers workers that are injured during and in the course of employment. And it's important to it's not just workers, it's employees during and in the course of employment. Now, that little sentence there, or that little description, has a lot of words that are often litigated throughout workers' compensation because, we argue about what the meanings of some of those words are. So one of the first things, we look at is injured. And there are several types of injuries that are covered under workers' compensation. So the most common would be the traumatic, specific time and place injury, such as like a slip and fall, or you lift something and you hurt your back. That would be a specific traumatic injury. There's also repetitive type injuries that are claimed and covered under workers' compensation. So these are more of like maybe a person who types all the time or who grips things all the time. They may develop something like carpal tunnel or tendinitis. Those are the types of repetitive trauma injuries. And then workers' comp also covers occupational diseases. And those are conditions that arise based on the environment and the exposures that may be present in a particular type of industry. It's important to note that with workers' compensation, they cover the physical injuries, and they may also cover what we call physical mental injuries. So if there's a mental condition that arises from the physical injury, then that will be covered. Workers' comp no longer, used to, but no longer covers what we refer to as a mental injury. So if someone's, just take me for instance. So I'm a trial attorney and I have a lot of stress all the time. But if I develop any kind of anxiety condition because of that stress, that's not going to be covered under workers' compensation. But say I go to court and I trip in the elevator, I'm carrying all my files and I trip and I end up injuring my back. Or say, God forbid someone gets mad at me and they physically assault me. Those two types of injuries would be covered under workers' compensation because they're physical. If I had such a significant back injury that it, took a long time to heal, and I developed some kind of like, say, a depression over that because it arose from the physical injury, workers' comp could cover that. It'll be argued, it'll be fought, but it's allowed to be claimed. If I develop some kind of anxiety from the attack of the person, then, again, because it arose from the physical injury, that would be something that would be able to be claimed, as opposed to just the anxiety that came from the stress itself. So injured is a loaded word. So that's a highly litigated area. During and in the course of employment. So during typically refers to the hours that someone works. That's usually, identifiable, except now when you have so many people working from home and they're working at all different hours, most people don't keep regular schedules, whole nother topic for a whole nother presentation. But, during is another word that's often litigated, depending on the facts of the case. In the course of employment, so in the course, that really refers to the duties and scope of the person's actions. You have to be effectively engaged in what would normally be your duties or the scope of your work to be covered under workers' compensation. And there are situations where that is litigated and someone's doing something that maybe is outside of the scope of their employment. They've deviated from their employment in some way, and sometimes that's litigated. And then, of course, we get to the employment part of it. Workers' compensation covers employees. It doesn't cover, and you don't have to get insurance for independent contractors. We'll get to this a little later, but that's a big area of concern. So sometimes, the litigation will be about, was a person an employee and should they be covered under workers' compensation insurance? There's also something called the coming and going rule. So although we're talking about, are you injured during and in the course of your employment, a lot of people will ask, well, what if I'm going to my employment and I get injured, or I'm going, from home to work or from work to home? The general rule is that no, that's not covered. That's not, even though you have to travel to get to work, it's not considered during and in the course of your employment. There are exceptions for especially for first responders, which again, we won't get into. And are some other exceptions, but the general rule is no. And we get asked that a lot. And like I said before, with working from home, a lot of people working from home, all of these lines are blurred, which, are becoming issues that really, it's just litigated. It hasn't really been figured out. There's no clear lines yet. So that's just something to be aware of. Okay, so workers' compensation is a purely it's just a created system. It was done by statute, and it was done a little over 100 years ago. It's about 109 years ago, at least in Connecticut, established the Workers' Compensation Commission and the rules surrounding it. It used to be like, when you think of workers' comp, someone who's injured during and in the course of their employment, it really is a personal injury. They've suffered a personal injury. So you suffer personal injuries outside of work, and you can be in a car accident outside of work. You can have a slip and fall outside of work. You can have, your dog bite case outside of work. Those are all personal injuries. And the normal course to litigate those is through normal, you'd file a claim, normal superior court. You'd have to retain an attorney. Most people retain an attorney and go through a very long process before you either settle with the insurance company or you go ahead and, you have your trial. So a long time ago, workers' comp is essentially, they took the injuries that happened during and in the course of employment outside of that system, and they created this separate system to handle it. So instead of going to superior court, you go to the Workers' Compensation Commission, and there are all different rules with how to file a case and how that case is supposed to be handled, and how it's even litigated. And even your appeal rights, it's all different. It's all condensed into this the separate workers' compensation system. And again, you can go into the history. It would take too long. We can go into the different reasons. That one of the main reasons is in order to, the goal for workers' comp is to get injured workers back to work as quickly as possible. That's the main purpose, and also to motivate employers to have a safe working environment. So what they did when they created this, of course, there were interests on both sides, as you can imagine. There was the people lobbying for the part of the employers, and there was people lobbying for the part of the injured workers. And the compromise that was made was that there is a basically like it's called a strictly liable. Employers, for if you are injured on the job, even if it's no one's fault, no one has to be negligent, no one has to be reckless, you're just injured, you trip even over your own 2 feet going down the hallway and you get injured, the employer is responsible. That insurance has to cover you if you are injured. So we call that no fault. They don't have to prove, or you don't have to, the injured worker does not have to prove that the employer was negligent or reckless. On the flip side, your benefits are less than they would be if you were to be injured outside of work. So the biggest is that like there is no pain and suffering component in the workers' compensation compensatory system. You get nothing for that. And a lot of times that's a big number that you get. And it's also the number that, you know, is probably that can fluctuate the most outside of workers' comp. If you go to a trial and you have a jury hear your case, that's going to be a big number that could be awarded. You cannot claim that. You get zero for pain and suffering. They don't deny that you are suffering or that you have suffered, but there's just nothing for it. So that was like a big win on the part of the employer, just like the strict liability was a big win on the part of the employee. Also, workers' compensation is the exclusive remedy for the most part, unless there's a third party that's involved, which again is beyond the scope of this presentation. But no matter, even if the employer is negligent or is reckless, for the most part, you are stuck within the workers' compensation system. You can't sue the employer outside of workers' compensation for the most part. Like I said, there are exceptions. And there's also reduced benefits that the employee gets. So the employee, it's considered a safety net, workers' compensation. You don't get your full you don't get your full lost wages, you get partial of your lost wages. And there's a limit on lost wages that you can get. There's a lot of schedules that determine formulas that determine what your compensation is. So it makes it a little bit easier for insurance companies and I think even employers to kind of gauge their risk a little bit better than some things like if you were able to sue them outside of workers' compensation. Let's see. So there was a trade-off there, a big trade-off. And if you're, depending on who you're talking to, if you're talking to the employers, they'll say that, you know, they have it bad. And if you're talking to the employees, they'll say they have it bad. But you know, it's the result of a compromise. And they always say, what's a compromised agreement? You know, neither party is happy. So this just rings true. So the types of benefits that you do get for workers' compensation, or you do give if you're the employer through your workers' compensation insurance, is first and foremost medical treatment. Medical treatment has to be provided immediately. And the employer has the right to determine what the first, where the first treatment takes place. And oftentimes they're responsible for transporting, if needed, transporting the employee to get that initial treatment. After that, the employee is allowed to determine where they receive their medical treatment. If there's a way that if you have an approved plan, some employers can have an approved plan approved by Workers' Compensation Commission, then the employees have to pick treaters within that plan. But if they don't, they can really go to any licensed provider in the state of Connecticut. Does have to be a Connecticut provider unless you get approval from Workers' Compensation to treat outside of Connecticut. And there's various reasons why that might happen. Lost wages. So typically, if a person suffers any kind of significant injury, they're going to be out of work. Sometimes it might only be for a week, 2 weeks, could be for a year, 2 years, depending on how bad the injury is. So like I said before, there's a, you don't get paid your full wages, but you get paid, it's like about 70, there's a formula, it's a very convoluted formula, but it comes out to about 75% after taxes is what you end up with. And from the day the person gets injured, the employer would have to supply to the insurance company the wages that employee earned for the 52 weeks prior to the date of injury. And then from there, they calculate an average weekly wage. And from there, they determine what your compensation rate is by putting it through that formula. So everything, all of your benefits are kind of tied into whatever your comp rate. You'll hear that if you're involved in any kind of accident or have an injured worker, you'll hear comp rate, compensation rate. Everything ties into that compensation rate. Permanent partial disability benefits. If after someone has finished treating, they are left with a permanent disability, so the doctors couldn't get you back 100%. Whatever injured body part will usually be given some sort of a rating. So you could have maybe a 10% rating of your loss of use of your arm. You could have you got a 15% loss of use of your back. Those are called, that's called a disability rating. And for workers' compensation, we call that permanent partial disability. So there are benefits that are tied into that rating, again, using a formula and based on your compensation rate. So just as an example, so every body part is actually assigned a certain number of weeks, the maximum number of weeks that you can get as an injured worker. You'd have to lose 100% of that body part to get the full number of weeks. If you get a percentage of the body part that's disabled, then you get the same percentage of the total benefits. So just by way of an example, your neck, according to the powers that be, is worth 117 weeks of benefits total. So if you suffer 10% of your neck, disability of your neck, the maximum amount of benefits you can get for that disability would be 11.7 weeks of benefits, which doesn't sound very much, because it isn't very much. So just as, again, by way of an example, if you had a $500 compensation rate, your 10% of your neck would be worth $5,850. And that's what you would get total. Can't get any more unless your disability increases. By way of comparison, if you had $1,000 a week comp rate, then you would get $11,700 for that same 10%. Now, I'm sure that the person who makes 500 is gonna, miss the neck just as much as the person that makes 1,000. But again, they don't go by, it doesn't go by pain and suffering, and it just goes by, everything is kind of tied into that comp rate. If after you reach maximum medical improvement, you still are not able to return to work full time, you may have a lost earning capacity. There are benefits that can be paid for that, but they're limited by the total amount you received for your permanent partial disability. So if you're stuck with 11.7 weeks for your permanent partial disability, that's what you're stuck with for the lost earning capacity. So you can see how really limited the benefits are, as kind of the flip side of gaining that strict liability, not having to prove fault. And then last, there's job retraining. If you can't return to your prior job or employment, and I don't mean the employer, but your prior type of work because of the injuries that you received, then the state of Connecticut has a program whereby you they'll either do on-the-job training, or they can return to your older employer and maybe recommend some sort of modifications, reasonable modifications that can be made so that you can work. Or you can they can pay up to some college to retrain you completely or re-educate you to try to get you back to work. And that's something that the state provides as a benefit for workers. And they try to do job placement too. And employers who take on these employees who have been injured through this program do get some sort of benefit in the way of, they get some kind of the payback for the wages. The state will cover the wages for a certain period of time. So before I get into the actual flow of a case for the employer, are there any questions that need to be asked right now or need to be answered right now?
Yes, Kathy, it's Bob. We do have a few questions. The first one is from William. What are the benefits of a 1 or 2 person LLC running a B2B technology consulting service business from home to acquire workers' compensation insurance? Occasionally, there might be on-site client visitation, example for meetings or to reboot a server, but it's not the norm.
Okay, if I understand the question, that would be beyond the scope of this presentation or something that we can discuss offline, but I would need a lot more information and in order to give you information, I apologize. Okay,
that's great. And when Kathy will have her contact information available later on, so you could reach out directly. We have another one from Ron. Are the lost wages taxable?
They are not taxable.
Okay, that's all we have at this time.
Okay. All right, so the basic flow of a case from the employer's perspective. So obviously you want to first obtain your workers' compensation insurance for all employees. Now, like I said before, this is where a lot of employers get tripped up and can really have serious consequences. You have to cover employees with workers' comp insurance. People who hire independent contractors who really are independent contractors or casual laborers, you don't have to have workers' compensation coverage for them. Again, it's beyond the scope and just beyond the time for me to go through kind of the checklist for these, but there are, you know, you can contact us. We can give you the links to the checklist, but there are checklists that are located through the IRS website and also through the state, which give you kind of a lot of questions to think about. And if you answer yes to, you know, a certain number of them, then it's probably more likely than not that it's an employee. But if you get it wrong, as we'll get to in the end, there are, you know, it could have significant repercussions in terms of not only fines and possibly criminal charges, but also just, you know, the civil penalties and having to cover and repay the state for anything that they might have to put out could be catastrophic for a business. So it's really, really important that you, and of course your insurance company should be able to assist you with that, you know, determining that as well. And of course, you can always also contact an attorney. But you really, really, really need to be careful that you have all of your employees covered and you have the right number of employees, you know, provided to the insurance company. Much easier than dealing with the repercussions afterwards. Once you get through the workers' comp insurance, if someone gets injured, like I said before, you have to immediately provide medical treatment and provide ongoing treatment. And again, this will be done through your workers' comp coverage, but ultimately it's the employer that's on the hook. So I'm just letting you know what is supposed to be provided. As the employer, you're usually responsible for the first report of injury. It's a form that needs to be filled out, which gives the basic information about the employee's injury and the circumstances surrounding it. And you also have to notify your insurance company. If you have workers' compensation insurance, part of your contract is that they need to immediately be notified in the event that anyone gets injured, because they want to jump on that right away. They want to get the information right away, and they want to start processing or defending right away. And then it's really important for the insurance company to get that what we call wage statement. So that is that 52-week history of wages, so that they can start to calculate the average weekly wage, and then from there get to that compensation rate. Like I said, everything's tied in, and in order for them to start paying the employee even on a temporary basis while they're out of work, they need to have some idea of what that comp rate will be, and they rely on you to provide them with those wages so that they can calculate that. There's a lot of times when, you know, I'm getting contacted by people and they haven't gotten their check, and I contact the insurance company, and like one of the things they say is they're still waiting for the employer to get them a wage statement. You know, that's just not good. Not good. That's not an acceptable excuse. That's not something that I accept. It's not something the Workers' Compensation Commission is going to accept. So you really got to get that, get the paperwork over to the insurance company and just cooperate in any way you can, because it allows them to process the claim timely. When things don't happen timely, that's when people start calling attorneys. We'll get to that later. Let me see, where are we? Obviously, then if there, whatever workers' compensation benefits are due at that time, so if it's usually the medical treatment and the out of work is usually, you know, they will start to get paid. You will periodically have to communicate with the insurance company or the insurance company's attorney as needed, depending on whether it's an accepted case or it's not an accepted case, or if they're not sure if they can accept the case. They're going to need information from you as the employer to help them manage that case. So you do need to be actively involved. And like I said, the faster you respond, ultimately the better. Sometimes, like I said, the employer can, or the employee initially gets the medical treatment for the employee, and then the employee will then start treating someone with someone else. And sometimes the insurance company might want a second opinion. So that's called a respondent's medical examination. So the injured employee is typically referred to as the claimant. The insurance company and the attorney are typically referred to as the respondent. So If a second opinion is wanted by the insurance company, they will arrange it, they will pay for it, and they will even provide transportation for the employee. And then, you know, of course, there'll be a fee for that. And then a report will be issued, and that's called a respondent's medical examination. So sometimes they just want a second opinion. If the treating physician and the second opinion don't match up, then sometimes a third opinion is required. And usually that's something that the commissioner orders. The insurance company still pays for it, but the commissioner will order it if they feel it necessary. And that's called the commissioner's examination. And that sometimes helps determine, you know, what either what treatment or extent of treatment will go forward. The insurance company or the employer is also responsible for transportation to both medical treatment and for hearings. Now, most people drive themselves or they have someone drive them. In that case, you just have to pay for mileage. But sometimes they don't have the transportation. And then you have to, usually they're provided with a cab or some other sort of transportation service. If the employee is able to work, but they're still treating for their injury, they are allowed to go to treatment during work hours. You as an employer are not allowed to demand that they say receive their physical therapy outside of work hours, even if it's available. They're allowed to do it within work hours, and they're allowed to be paid for their lost time. So the employer normally fronts that money and then normally is reimbursed by the insurance company for that type of payment if they lose time from work for that medical treatment. Different if an employer is out, if an employee is out not back at work, then they'll get paid directly by the insurance company. If any injury results in death of an employee, then there are survivor benefits that belong to family, to the immediate family. And again, that's a whole nother presentation, but just be aware that that's out there. So that was all of kind of the practical, a very fast overview of the practical kind of hands-on things as an employer that you need to do once an employee is injured, and kind of an overview of what types of benefits are paid, which you'll be privy to. Yeah.
Maybe before you move on to this next section, we did have 2 or 3 additional questions, which I think would be like a good idea to take these at this point.
Okay.
There's one from Hector. How many weeks can workers' comp pay for an employee that was injured during working hours if the employee is taking more than 2 years to recover?
Well, if the question is when you say how long do they have to pay, you mean for like lost work?
I believe that he's referring to how many weeks can workers' compensation pay for an employee that was injured during working hours if the employee is taking more than 2 years to recover. Like, in other words, would workers' comp pay for the full 2 years?
Yes, if it's medically determined that the person cannot work, and the reason they cannot work is directly due to the injury, the work injury, then, and even if it lasts 2 years, the insurance company still has to pay. In fact, someone can be permanently, totally disabled, which actually we'll get to, and they can be paid on their weekly benefit perpetually for the rest of their life. So like when you suffer an injury for, like, say, a car accident or a slip and fall, you either settle your case or you go to trial and you get a determination. You either win the case, lose the case, right? But then the case ends. That's it. The insurance either pays out or it doesn't pay out, or the individual pays out or doesn't pay out, either by settlement or by award. Workers' compensation can stay open for the entire life of the claimant. So if they don't, most cases settle, which we'll get into, and they close, but technically neither the employer or the worker has to ever close out a workers' compensation claim. So it could stay open forever. So even whether someone's permanently disabled and they're getting paid, I've got some people who are getting paid, they're probably in their, I don't know, maybe 15th year and they're still getting paid because they are permanently disabled and they didn't close the case. Even if people stop being disabled, but say they're just, some people just don't want to close it because they think they might need medical treatment in the future. And I have some people, it's very rare, but I have some people who keep their case open for years and years and years, 20 years, because they might have to go back for medical treatment.
Okay, I think that that covers it very well. We have another one from Uchenna. As a sole proprietor, am I required to have workers' comp for myself, or is it optional?
It's optional. Actually, it's a very good question. So, and we were actually going to go into it here, but you have the option to cover yourself or to opt out of workers' compensation. But if you opt out, you do have to fill out a form and file it with workers' compensation, as well as probably forms for the insurance company.
And then we have a question from Kelly on age. What is the minimum age of the worker that can be covered by workers' comp? For example, farms can hire 14-year-olds.
That's an interesting question. I can't say that I definitely know the answer, but my inkling is you have to cover all workers. So if the laws allow a 14-year-old to work or a 16-year-old to work, you have to have it covered. I'm sure of it. If they're an employee, you have to get them covered.
That's great. And that's all we have right now. So I think you can proceed.
Sure. So on the legal side of things, when someone gets injured, the employee gets injured, when they're actually filing a claim for workers' compensation, everything is forms, very form-based. I'm not going to go into all the forms, but I did note the initial form just because it's very common to hear about a Form 30C, less common Form 30D. So a Form 30C is the main form that gets filed if someone gets injured. It just gives notice of the time and place and that they're making a claim, and they send it to both the employer and they send it to the Workers' Compensation Commission. The 30D is if there's a death, which obviously is less common, but certainly does happen, then that's the form that they fill out. And it just gives all of the information necessary for workers' compensation to open up their own file with the court. So instead of going to like Superior Court, which you would do if you got into a car accident to file a claim, you would go to the Workers' Compensation Commission. And there's various offices located throughout the state, depending on which jurisdiction you're in, just like with Superior Courts, but they're not located in the Superior Court. They're a separate building altogether. And they have separate, administrative functions and staffs. And it's just like a parallel type of facility to litigate matters. So once you officially get this form, this claim, then the insurance company on your behalf either has to file another form, and they either have to accept the injury and start paying, or they have to let everyone know that they're contesting the injury for some point. Now, if they accept it, it doesn't mean that you can never dispute the extent of the treatment or the extent of the injury. You have a right to do that. It's not like if you accept the injury, you just accept everything and you never argue anything going forward. That's not the case. But it does mean that you're saying, yes, I accept that this was, a person that was employee that was injured during in the course of employment. If they deny it, then they have to do that within a certain period of time. They basically have 28 days to either deny, to deny the case. Again, there's some exceptions. We're not going to go into all of that, but just it should, if something's going to be denied, it should be denied sooner rather than later. At that point, the claimant, the injured worker, has to, if it's denied, they usually will ask for a hearing. So they'll file another form and they'll ask for, to have a hearing. And that's like the initial time that you go, or the insurance company will send, a representative on your behalf to go to the hearing. And then that would start the litigation process as to how it's going to turn out, whether this is going to be accepted or denied. And most of the time you have to go to several hearings and may even have to do some what we call discovery. So maybe investigations, maybe some depositions, in order to gather more information. The most common type of discovery is in the most common type of claims for denial is that a person had maybe like had a previous injury and that they really didn't get injured on the job, or they got injured elsewhere. And a lot of times they'll want other medical records in order to see that. So that starts that litigation process through the Workers' Compensation Commission. If someone cannot work at all, again, whether it's in the beginning and whether it's a short period of time or a long period of time, then it's what they call they're temporary, totally disabled. And they're entitled to their full compensation rate for as long as they're temporary, totally disabled due to the work injury. If they either initially aren't temporary totaled and they can have a partial work capacity, or a lot of times, most common, someone's totally disabled, but then they get a work capacity afterwards once they start getting better. That's called temporary partial. It's when they can work, they're released maybe to light duty with some restrictions. And at that point, they're supposed to first try to go back to the employer, where they got injured. And if the employer can take them and hasn't, replaced their job, or, it can still use them depending on how long they've been out, then a lot of times they will take them back. If they're not able to go back to their employment because either the restrictions are such that they can't do their job, or if they just did not have, if the employer no longer has a place for them, then they have to start doing job searches and they try to have to seek work elsewhere. And during that period of time, they're entitled to get some benefits. Again, it could be their full compensation rate in some circumstances, or it could be something less, depending on what's either ordered, agreed to, or what the circumstances require. While they're trying to get reemployed and while they're still healing. And sometimes it's fluid. Sometimes people will be totally disabled and then they get light duty, and then later on, they have an exacerbation, they get disabled again. So that kind of flows back and forth while people are treating. But by and large, most people suffer total disability period and then slowly get better, hopefully get returned back to work, and then continue to finish their medical treatment and eventually reach maximum medical improvement, which we'll get to shortly. So the hearings structure, initially you go to informal hearings at the workers' compensation level, and they are very informal, where the commissioner, who we now actually call them judges after all these years, they've gotten the title administrative law judge. So you'll hear me say commissioner, but it's really a judge now. They actually just sit at the table with you, and it's like a conference table, and the initial hearings are very informal, where they're just exchanging information. There's no like testimony, and there's no evidence being formally presented. And they try to work the cases out just by discussion and recommendations at first. If that doesn't work out, then they do something called a pre-formal, where it's a little bit more formal, but again, it's more like a settlement conference than a trial. If that doesn't work out, then you go on any issue that's disputed. You go to a formal hearing, which is what we think of as a trial, where now the judge is actually sitting elevated apart from everybody else. You're sitting at a conference table, or your client sitting at a conference table, or the injured worker, and someone actually has to take the stand. They get sworn in, they give their testimony, and evidence is presented. That's what we think of. That's the formal hearing. And that's the stage at which the judge can then issue a ruling. Prior to that, it's just called a recommendation. The appeal from a formal goes to something called the Commission Review Board, which is like the appellate court for workers' compensation. After that, you can go to the actual appellate court. And then after that, you can go to the Supreme Court if the circumstances allow. So eventually, hopefully, someone will reach what's called maximum medical improvement with their medical treatment. The doctors get them as far as they can, and there's really no likely prospect that they're going to improve. That doesn't mean that people won't periodically need ongoing maintenance treatment, which I know frustrates a lot of employers and sometimes the insurance companies, but sometimes people need some treatment going forward just to maintain their ability to work. And that has to be covered. But curative, what we call curative treatment that's going to actually make you better, usually ends at some point, and they call that maximum medical improvement. And that's the point where the doctor will assign a rating for a disability if it exists. And that's also a lot of times where you'll have that second opinion and third opinion sometimes come in because, you know, the insurance company maybe doesn't like, you know, what the primary physician gave as a rating. Usually they think it's too high. They're hoping that maybe they'll send them to another doctor and get a lower rating. And if that happens, sometimes we compromise the rating, sometimes we don't. It all depends on circumstances. Permanent TT, we kind of talked about. Sometimes people, even though they've reached maximum medical improvement, can never really return to any type of employment. And in that case, they really are disabled, and that ongoing comp rate is just ongoing. And sometimes, you know, people at that point, they'll settle, or the employer will want to settle. We'll get to that in a minute. Most people eventually do return to work. If not with the original employer that they got injured with, they will return to work in some other capacity, and eventually be out of, you know, ongoing workers' compensation benefits. Again, their case may still be open because it's not closed, but they're not actively receiving any treatment, and they're not actively receiving any benefits anymore. Again, settlement is something that's a completely voluntary process. You can't go to a hearing on it. You can't have a trial on it. A commissioner, a judge can't force either party to settle. So most people want to get out of the comp system. They're sick of it by the time they reach maximum medical improvement. A lot of insurance companies, they want to cut, you know, they don't like open-ended cases. They don't like to maintain risk on their cases. So we will negotiate and try to come to a settlement, to a number that both parties are equally unhappy with, I guess is the best way to put it. And then if it's accepted, it's reviewed by the workers' comp judge. And if the judge approves it, then it closes the case, the lump sum is paid, and then that's it. Everyone goes their separate ways. So I come in mostly when there are problems with a workers' compensation case. So from an employer's standpoint, it's in your best interest to have your insurance company be on top of things, for you to give them all the information they need, and to really kind of process their cases timely, accurately, and fairly. When those three things don't happen, that's when clients get frustrated, claimants get frustrated, employees get frustrated, and they end up calling me to say, hey, I didn't get my check. I can't get a hold of the insurance company. They're giving me the runaround. You know, they didn't pay for my medical treatment, or, you know, they're not giving the doctors, the employer's not giving the insurance company what they need, or my doctor's not getting the authorization for me to hit my MRI. Most people, I haven't done any official statistics on this yet, but I just know from over 25 years, a lot of people don't think to hire an attorney when they get injured on the job, where it's different when if they get into a car accident, they think right away, I need to get an attorney. Not so with workers' comp. I don't think a lot of people even realize, because they haven't really thought about it, that it's not, you know, they think that they're suing their employer. They don't realize that they're really making a claim that is then going to be handed over to an insurance company, you know, to be paid out. And a lot of people call and they feel guilty to sue their employer. And I, you know, I kind of have to educate them on that. But, you know, that's what triggers them calling me oftentimes isn't, hi, I just got injured. You know, I need you to help me. It's, I'm having trouble with the insurance company. So that's something that kind of really be important and talk to your insurance company about. If the insurance company doesn't do what it's supposed to do, then there are fines that have to be paid by the insurance company. And ultimately that's going to raise, you know, eventually it trickles down and it's going to raise your rates. So there's some insurance companies that handle claims, you know, better than others, some claims reps that handle claims better than others. And when they don't, they could cause a lot of extra fines and fees. You know, there's fees and fines for undue delay. There's fees and fines for like stopping benefits before they're supposed to, when they're not supposed to, for unreasonably contesting a claim. You know, you can get hit with attorney's fees and fines. For paying things like later than you're supposed to be paid, you can get hit with fees and fines. And, you know, you better believe it that me and every other claimant's attorney out there, you know, in addition to making our clients whole, we're going to make sure that we make ourselves whole too. So we're going to go after those sanctions, interest, and attorney's fees. So just bear that in mind. So the workers' compensation insurance, so those fines and fees and interest that I just talked about, that's just when the case isn't handled very well, right? If you don't have insurance that you're supposed to have, that's a whole nother level of fines and sanctions and trouble. So if you don't have the insurance company you're supposed to have, there's something called the second injury fund, which is like a safety net for the employees. Like they're not just out. They have to then, the claim gets transferred to the state fund, and they manage the case in place of the insurance company, and they pay the benefits in place of the insurance company. What happens to the employer is now the state goes after the employer, and they go after them. You can get fines, sizable fines, fines just for fines itself. I think you can go up to $50,000 in fines, but then they can also make you pay back the benefits they're paying to the employee. So, I mean, if you can imagine a scenario where you have someone who's seriously injured and they're on this, this permanent TT or TT for years and years, the employer is going to be ultimately on the hook for a lot of that money. And they can also stop you from running your business if you're not complying with it. And if they find, now all of that is if you just made a mistake. If they find that you actually knowingly and willfully either misclassified workers or did not insure, then you can actually be charged with a Class D felony. So really, really, really serious trouble. In fact, I mentioned before that I represent claimants. The very few times that I've represented employers over the past, 25 years have been for the ones who did not have insurance. They didn't have an insurance company to go to, and they were getting hit with the state fines, and, they ended up contacting me to assist them with that. All I could do in that case is get them compliant really fast and try to stop the bleeding, and then maybe negotiate, the fines, which is what I've done in the past. But, they add up that they get fines sometimes daily. So it's just not a good thing. How are we on time?
We're a little short on time, and we do have a few questions to take, Kathy, so we could wrap up and leave a couple minutes for questions. That'd be great.
Okay. All right. So these other concerns, again, these are all topics for a whole nother presentation, or possibly several presentations, but I just felt like, probably it might be a question for some people, and it was good enough to touch. So health insurance. So if you look at the actual law, if you look at the statutes, it says that employers have to maintain health insurance for employees when they suffer a workers' compensation claim. That's actually not the case. The Supreme Court, in another matter, in another state, ruled that was an unfair taking. So that even though it's on the books, it's not an enforceable provision, and you don't have to do that. So for employers, that's probably good news. You don't have to continue to pay health insurance for an employee who's not there, not actively working. For employees, it's a real concern for them. As you can imagine, someone who has maybe their whole family covered on health insurance, and, it adds insult to injury that now they're injured through the job, but now their family doesn't have health insurance. And it is a terrible situation. It's a conversation I absolutely hate to have. But that is the law. I can't get around it. That's the way it is. There are some employers that I've seen, that maintain the health insurance for a certain period of time, hoping that the employee will come back. But that's not something that they have to do. Continued employment. So it is absolutely against the law to retaliate against an employee for filing a workers' compensation claim. And there can be serious consequences to doing that, in addition to what you pay for workers' compensation. And your workers' compensation insurance does not cover that claim. So you can't discharge them, and you can't treat them unfairly simply because they filed a claim. That doesn't mean that you have to hold their position open if you have to fill it. You just can't fire them simply because they filed a workers' compensation claim. So just be careful, with that situation, that you don't get, accused of doing that. Because some people can't work for long periods of time and sometimes permanently, disability insurance or Social Security disability may kick in and they may start receiving those benefits. There is a certain way that those affect what workers' comp benefits they're receiving. Again, it's way too complicated to go into, but know that that is an issue. And the attorney should know how to handle it. It gets offset. You don't really get it. The employee doesn't get a double pay. And third-party actions, you may just hear the term third-party actions. That's when, if you have someone outside the work, so it's not a co-employee, but there's someone outside that's involved in the employee getting injured. So the most typical would be, say I'm driving to court, all right, and I'm covered under workers' compensation. I'm driving to court and I get into an accident, so it's somebody else's fault, and that other person does not work for my company. There can be another case that either the employee or even the insurance company / employer files. And sometimes the insurance company or the employee the insurance company can get reimbursed, and the employee may be able to get more than what workers' comp allows for. But those are issues that are related to workers' comp, but really separate.
Okay.
That's about all we have time for today.
Yeah, that's great. We do have a few minutes left for questions, and we have 3 or 4. So the first one is from Kelly. If a person is not getting paid and doing a working farm share, would workers' comp cover them, or is a waiver better in that case? So they're not getting paid. They're doing a farm share.
If they're doing a farm, well, then it would depend on if they're classified as an employee, but it doesn't sound like that would be an employee. I'm really not qualified to talk about farms. I got to be honest with you.
Okay. Here's one from Hector. If the employee is not able to work for 3 days after an injury during working hours, does the employer pay for the 3 days and then the employer gets reimbursed, or does the workers' comp pay a separate check to the employee? If the workers' comp pays a separate check, do they pay 2/3 of the salary?
So in order for an employee to be covered under workers' compensation, you have to be out of work for 3 days or more. So, or over 3 days. So yeah, 3 days or more. So if if someone's only injured and out for 1 or 2 days, then they would just go by if they had sick time or if they had to take vacation time. It would be whatever the benefit is with the employer. The workers' comp insurance doesn't cover that. If it's so if they're injured for between 3 and 7 days, I think it would depend. You have to look at your workers' compensation policy, but I think that the employer would pay and then the insurance company would reimburse you for those few days. If the person is injured, I think if it's 7 days or more, then if workers' comp has to kind of go back and pay all of that from the beginning. It's kind of a weird formula for that little less than a week, and that's pretty much how it goes.
Yeah. Okay, that's very clear. Here's one. How do you pick the right insurance company for workers' comp? Is there a list on the state website? Is it a separate insurance company on its own, or is it usually all inclusive?
I'm not sure what you mean by all inclusive. I mean, workers' comp is a separate policy. I mean, usually as a business owner, you need your professional liability, and then you need your business liability, and then workers' comp is a separate policy. Now, some insurance companies may offer all of those different policies, but they are separate policies. But you don't have to. You can go and get separate, workers' comp, and the best way is really the reason or the way you do business with anybody else is really to, you'd have to talk to different representatives, find out who you're comfortable, who maybe they recommend and they work with, and just ask a lot of questions about, their coverage and how well they communicate, and do they, what ratings that they have, I guess is the best way. There's no, I don't know if there's an easy answer to that, but it is a separate policy. I can tell you that. And I would just rely on, talk to different representatives, different brokers, and see who they recommend. They know who, you know, they probably know who are the better at handling things than others and who communicate with the employers well.
Okay, that's great. And I think we'll end on this question. As an employer, are there any best practices to do once an employee has gotten injured? And what if they do not file a workers' comp claim?
Well, the best practices would be to, you know, make sure you do all you're supposed to do to get that employee treatment, and to work with the insurance company and get them the information they need as quickly as possible, because that helps them to do their job, and ultimately it helps them to help the employee. The best scenario for everyone is to get the employee treated as quick as possible and back to work as fast as possible. I mean, that's the best scenario for both the employee and the employer. I'm sorry, what was the second part of the question? It was the best practices, and then what was the other part?
And it's what if they do not file a workers' comp claim?
Yeah, well, it's still the burden of the employer, and it's very important that the employer still notify the insurance company, because the insurance company will get in touch with them. And there are tons of employees who never actually file a workers' compensation claim, probably because they got very good response and very supportive response from the employer. They got a very good and very supportive response from the insurance company. They were able to get their treatment. They didn't run into any problems. And between the insurance company and the employer, they helped them through the process and to be able to get back to work. Like I said before, a lot of times people don't even think of hiring an attorney or filing a claim until there's a problem. So best practices would be to treat your employees well and to do what you're supposed to do with regards to both your insurance company and just do right by the employee. And that's probably the best thing to do.
Okay. Well, that's all the time that we have for questions. Just a reminder to people, the webinar is being recorded and the materials will be available the next day or so on the fairfieldcounty.score.org website under on-demand webinars. And the next live webinar will be Thursday, March 17th at noon. And the topic is marketing the e-commerce business with Cliff Enico presenting. And again, you can find more specifics on our website, fairfieldcounty.score.org. Again, if you'd like to take advantage of the free individual mentoring, you can click on the yellow bit.ly link that was on the screen. And if Kathy just advances the slide, we'll show it to you again. And also, if I could ask you to please fill out your evaluations at the end of the webinar, they would help us greatly as we go forward. Thank you to the Monroe Chamber of Commerce and Edith Wheeler Memorial Library for their help in planning today's webinar. And on behalf of SCORE, I'd like to thank all of you for attending today's live webinar. And in closing, a special and big thank you to Kathy for a great presentation today. And stay well, everyone, and enjoy the rest of your day. Thank you.
Thank you.